Hi, I'm Bobby Schwartz. I'm a partner in the Quinn Emanuel law firm here in Los Angeles. We're going to spend the next few minutes talking about deposing an adverse expert witness. It can be the most fun you'll have in a case. Why do I say that? Because the rules are set up to help you expose bad work by experts. Now, there are plenty of good and honest experts out there, but there are also plenty of quacks. Your job is to use the 7 hours of deposition examination to find out what you're dealing with and to get the ammunition you need to deal with this person at trial. So here's what we're going to cover. First, an overview on deposing an expert. We'll talk about next substantive, or rather non-substantive attacks, and then we'll cover some substantive attacks as well. Let's start first with an approach or a philosophy to approaching an expert witness and some important considerations. First, this is a weak moment in the other party's presentation at trial. The jury often has sympathy for a party witness. They have none for an expert. And so if that expert does not do a good job, the jury can think that the sponsoring party has no case or defense. So it's important to take advantage of that. The other thing to be on the lookout for is to co-opt the expert witness. If you can make the other side's expert support your side of the case, you'll likely win. And often the adverse attorney will give an expert a narrow assignment or not give the expert all of the relevant documents and information. If you can show the expert important information that was withheld, you may get the expert to agree with an important element of your case or defense, and then the other side is in big trouble. Next point philosophically, save nothing for trial. Some lawyers like to spring things on a witness at trial. I don't, for 3 reasons. First, you don't really know how something will play out in front of the jury. Things can go wrong, and you can look foolish and damage your case. Second, you're taking a risk that the expert does not already know how to respond, or even worse, based on something that happened at the deposition, will be ready, will have figured it out before trial, and it will blow up in your face. So if you don't get it on the video at the deposition, you will never get it. 3, most cases settle. So whatever attacks you have in mind will translate to nothing in negotiating leverage for settlement if they aren't in the deposition transcript. Let's talk about another important thing to do. Lock in value propositions before you get into the substance. What are value propositions? These are statements that no reasonable and honest person will resist, but they'll be important to your case. The expert may not realize that he or she did not adhere to them in this particular case. So before I get very far into the deposition, I want to lock in the expert into some ground rules. For example, ask the expert to confirm you approached this case without any bias or preconceived notion of what your opinions would be, correct? Or, you understand that your job was to gather all of the necessary information, evaluate it using your expertise, and reach whatever opinions you thought that the information supported, regardless of whether your opinion would help or hurt the party that retained you, right? Or, you did nothing during your work that would cause you to reach any opinion that favored the party that retained you. You were balanced and honest at all times. Now, who can argue with those things? There are also usually case-specific value propositions to lock the expert into at the start. The point of this is to come back to these value propositions anytime you've extracted an admission from the expert that he or she failed to adhere to at some point during their work. And then you make them admit that they fell below the standards that they said they were adhering to, and then see if you can use that to force them to change their opinion or admit that it is not honest or reliable. And ultimately, that's really what you need. Next, you have to lock in all facts and assumptions. You want to be sure that you've identified everything that the expert looked at and assumed and considered. This should be done using one question that, after you've explored and probed the expert, asks the expert to confirm that something along the lines of, in preparing your opinions in this case, you considered the following information and nothing else, A, B, C, etc. Why do you do this? Because it prevents the expert later on in the deposition from worming out of an admission that they failed to consider something important. It's important also to use these rules to test your own expert on these issues. It doesn't help your client's case if your expert engaged in the same shoddy or dishonest conduct. So, before you disclose your expert or turn over a report, make sure that your expert will give good answers to the same attacks you plan to use against the other side's experts. All right, let's talk about a few non-substantive attacks on an expert's credibility. These attacks have nothing to do with the opinions the expert is going to give. In that sense, they are freebies, but they are often powerful and easy to get, and they can leave the expert on the ropes. So, let's go through a few of them. First of all, qualifications. Maybe you're wondering why anyone would even question an expert's qualifications. But a lot of so-called experts, people whose CVs look impressive the first time you look at them, venture into areas or industries with which they don't have enough experience or knowledge to give proper opinions. Perhaps they understand accounting, but they don't really know how cost accounting works in the healthcare industry. And nonetheless, here they are expressing opinions on that for your adversary. Now, most of our adversaries will find someone with the right expertise. But sometimes real experts will decline to offer the opinion that the lawyer is looking for. So the person retained will have to stretch. They'll have to reach to render an opinion they're really not qualified to make. To find out, you should ask the expert how many times a judge has allowed them to present at trial the opinion they are giving in this particular case. Ask how many times in their work they've actually evaluated the issue they're being asked to evaluate and give testimony on in this particular case. If the answer is none, then ask them something like, in your X years working in the Y industry, what's the closest thing you've done to addressing the issue you're addressing in this case? You're looking for an answer that bears as little resemblance to the opinion that they're giving in the current case. Depending on the answer, you can then ask them to agree that what they just said is very different from the issue in the case, and therefore they are straying far afield from their comfort zone. Another area of non-substantive attack is resume padding. Now, before the deposition, you'll have reviewed the expert's CV to ensure that it's correct. Some experts will include, for example, degrees they enrolled in but did not obtain, or they'll embellish what they actually did at a company or on a project. Ask the expert to confirm first that the CV you've marked as an exhibit is their most up-to-date CV. Then ask the expert whether he or she has any education or work experience since graduating high school that is not on the CV. If so, ask the expert why he or she omitted it. Also, get the expert to confirm that he or she knows that the jury may rely on the information on his or her CV in deciding whether the expert is an expert in the area and is credible. Furthermore, ask the expert to confirm that he or she knows that the jury may rely on the information in his or her CV in deciding how much weight to give the expert's opinion. Most experts will give you that. Then get the expert to confirm that he or she did not put anything on the resume that would mislead the jury or cause the jury to think more of the expert than is justified. This is a value proposition. Get the expert to confirm that he or she didn't pad the resume, and watch the expert's body language and facial expressions at this point. If you have found overstatements or inaccuracies in preparing for the deposition during your review of the expert's CV, now is the time to point them out. Ask the expert to confirm that the information is wrong, and most importantly, that the expert knew that when he or she provided it, he knew that it was wrong. Then ask the expert why he or she put the information on the resume knowing that it was not correct. Even if this is not fatal, when you get to the substantive part of the examination, it is going to make the expert think twice about going out on a limb or taking positions that the expert may have been asked to take but can't really support. So you're laying a foundation for a substantive attack. Another non-substantive attack deals with notes and time records. Your deposition notice should request all notes the expert took during the work. Depending on the jurisdiction, this may include notes of conversations with the retaining attorneys. If you get those notes, ask the expert to confirm that they've given you all of the notes that the expert took during the work, including notes of conversations with the hiring counsel, again, if those are discoverable. Some experts have a practice of throwing out their notes. Why? I'm not entirely sure. But the jury will be suspicious of anyone who does that. It's not as if this work was done years ago. It's usually done in weeks or months before the examination. Get the details of the missing notes. When were they created? How many pages were created? What do they reflect? When were they thrown out? And so forth. Ask the expert if everything he or she put in the notes that were thrown out is also in the expert's report. And then keep looping back the details of the thrown out notes with each question. Get the expert to agree that by throwing out the notes, again looping back the details of how long they are and what they included, the expert has deprived you of the ability to ask questions about their work and whether there are any inconsistencies between the notes and the report or the deposition testimony. Press the expert to explain why he or she threw them out. That's a really tough question to answer. And get them to agree that the jury might not think the expert did that, or that the jury will think the expert did that, to cover their tracks on unhelpful testimony. Timesheets, another non-substantive attack. Experts get paid for their time. Some will admit to not recording all of their time on the case. That gives an advantage to the party that hires them and suggests that the expert is favoring that party by donating a portion of their time to the case. If that happened, quantify it in dollars, and then ask the expert if he or she has done that in other cases or just this one. Then ask why they gifted X thousands or tens of thousands of dollars to a party and why they did it. Was it because they were not being efficient? Was it because it really isn't their area of expertise? Or were they trying to help them out even though they said at the start of the deposition that they weren't going to do that when you got them to buy into one of those value propositions? Honesty and completeness of the investigation is another non-substantive attack. You need to know everything the expert read and considered, everyone the expert spoke to, and everything the expert did in preparing the opinion. You need to know whether the expert chose not to look at something, or not to ask for something, or whether the expert asked for something but was unable to see it. Many attacks will flow from these answers, but of course, they're going to depend on the answers you get. You should talk with your expert on the issue to find out whether that is a sufficient investigation. And frankly, it's a good idea to have your expert at the deposition. Depending on the subject area, you should ask whether the expert consulted with anyone or anything to confirm that the investigation the expert undertook was sufficient. You also want to be sure that the expert has completed the work, given you all of the opinions that will be offered at trial, produced all reports that will be shown to the jury, and will let you know before that person takes the stand if they do any more work or reach any other opinions, and tell you what those opinions are.